form that we could argue that says, well, they could be right. He may have been running there in Satilla Shores for exercise and pleasure, but let's tell you another explanation that's equally, if not more
Hey guys,
plausible.
I'm getting this is all set up.
He's on probation. He's inside the English house. Matt Albenzi sees him in the house. All this is
Oh
on
man, I
video
messed it up. I don't know how to
and
turn
will
that
be
off.
testified to.
Oh, there
Matt
you go.
Albenzi
Okay.
then picks up his cell phone and calls
Hang on
the
a second here.
police.
Still working on all this.
Mr. Arbery comes out of the house, sees him, Mr. Albenzi,
Turn
and
the volume
immediately
up.
turns to his right and runs at a sprint. 5 houses up the street is Mr. McMichael in his driveway fixing boat cushions in the bed of his truck using
It
his
sounds like
truck
it's closing
bed as
arguments
a
here.
workbench. Sees Mr. Arbery running past, and as we all
Oh
know,
my
Mr.
Christ! I gotta get my
Michael's colorful
headphones.
expression
Sorry,
for what he saw
I know I'm
was
getting
hauling
feedback to
ass.
y'all. Crud!
And he said
I lost
he
my headphones.
wasn't out
How
for
does
no
one lose
Sunday
their
jog.
headphones? Probably
He
because
was
they hate their
sprinting.
headphones so bad
He looked like a
that they've come
wide
to
receiver.
this
These are things he said
awful
as he noticed him.
garbage that is
Now,
me.
obviously, he didn't know he was on probation.
I don't have my
And we're not
earbuds. I don't have
arguing,
my
at least I'm not
earphones. I have
here now,
nothing.
that Mr. Arbery's
I'll be
probationary
back. Hang on.
status is relevant because Mr. McMichael knew it. He didn't know it. But when the state says he was running that day for pleasure, and Mr. McMichael sees a person running and he thinks he's running from something, being chased by someone, as he told the police that day, then a reasonable alternative explanation could be, well, Mr. Arbery's running because he's on probation. He's been spotted at the least trespassing. At the worst, back in a house he'd been in 4 previous times where burglaries had occurred in a neighborhood where other burglaries and break-ins had occurred. And so when he was running at this sprint, not a Sunday jog, and continued to run until the end of this tragic scenario, a reasonable alternative explanation for that running could be, well, he's running because he's on probation. He sees a guy who's just had a cell phone to his ear, possibly calling the police, which in fact he was. And therefore, Mr. Arbery, who had had his probation revoked 2 times
Yeah,
before,
a lot more to running
for
outside.
which
It's
he'd
not
spent
mine.
time in the county jail, did not
Done.
want to be caught trespassing or caught and interrogated for previous entries into that
Guys,
house.
I've lost my headphones. How does somebody
so
lose
when the state
headphones?
says, no, he's just out for a Sunday jog, we
I have a Labrador.
ought to be able to attempt
A dog.
to rebut that by offering an alternative explanation.
Oh, jeez, I've got a
And I'm not arguing that it does.
earbuds
I'm
that have a
arguing
microphone
that
on,
it is an answer
and I hope they
that
don't
the
turn on.
jury should have before it,
Buddy boy.
so they can determine why he's running, not just because the state says he's out for a Sunday jog.
Let's see if this works any.
Let the jury decide which it is.
Oh, the sound should
We
get a
want to
little bit
be able
better for
to
you.
give this alternative
But
explanation. That's the argument that's in this short motion, and I leave it there and tap out for Mr. Sheffield to take
over.
all right, hang
I
on.
concur with that on behalf of Travis McMichael. Essentially, what we're talking about there is opening the door to the intent.
Where
of the
is
running.
Covered here in the motion that
It is. Yeah, that's why it's a simple issue. I hate that we got sidetracked. And Your Honor, we're going to continue to do our best to put issues in front of this thoughtful court in a way that gives the court time
All right,
to wade through.
I still
these
have
issues,
my
because we really
correct
are dealing
microphone.
with
Awesome.
the type of evidence that the rules of evidence say under 401 it's relevant But the court well knows, the state has argued against it, that it can dip into 403, but still be admissible relevant evidence under 401. So we understand the court is walking a fine line and trying to interpret. In addition to opening the door that the state has done repeatedly, and we believe will do during trial on this issue of running, it is intrinsic, not in the minds of the McMichaels, but it is intrinsic that this young man is on probation and has been jailed for failure to adhere to probation conditions by committing new crimes and by
Georgia Rule of Evidence
Court
401 that he just
and has
quoted
been
is
punished for that.
relevancy.
He is currently on probation at this time in 2 cases, and he has a longstanding relationship with the probation department for those failures. And so under the cases that we've cited, those courts note that when the defendant in that case, the one who's actually on trial and risking going to prison, the state was allowed to introduce evidence that the probation was there and relevant, because if he indeed, quote unquote, ran from the police because he was on probation, that showed his motive. So we do get back into the motive and the intent of Mr. Arbery, not as an extrinsic element, not as a 404B,
So
but as an intrinsic element to his
relevance,
life and circumstances at the
excuse me,
moment that he
relevance
chose
means that
to run.
past behavior
The video
that show
very
the
clearly
likelihood
shows
of current behavior.
that Mr. Arbery did not
That's
run into the neighborhood.
Easy way of explaining it.
It very clearly shows that he walked into the neighborhood, that he stood in the front lawn, that he looked left, looked right, looked forward, looked backwards, and then went into this home. And when seen and observed by the neighbor, he is running out of that house at a rate that is more than just a jog. The evidence will also show that he was informed, in fact, that the police were on the way, and that created more running and turning. And so we feel that we have a substantial basis for the jury to learn that he is running to avoid being arrested. And those cases that we cite, I think, are very clear. So
I'll tell you what, this guy's a better attorney already than Cal Rittenhouse has.
Is intrinsic. And these cases, clearly, as used against defendants, make that type of evidence real.
Final word from the state.
Thank you, Judge. That was quite a lot of speculation about what the state was going to argue in this case. An opening statement. Mr. Arbery was an avid jogger. And under the rules of evidence, especially
Oh, the times he has to run away from being arrested.
44446, habit and routine practice. Evidence of the habit of a person or the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with such habit or routine practice. So, Mr. Arbery being seen by people who live in Fancy Bluff running indicates that he's an avid runner. In addition, the state has no intention of putting in that he was only running for his health, only running because it was good for him, or anything along those lines. We actually have evidence in this case that was put forth through Larry English's testimony on December 17th. The third video from Mr. Arbery going into the Larry English open unsecured construction site is that Mr. Arbery steps outside, and you know what he does? He runs, and he runs away, and he runs onto the street and out of the frame. So there's actual evidence that when he was in 220 Satilla Drive, that when he left after staying there a few minutes, he ran away into the neighborhood, the exact same path that he took on February 23rd, 2020. And that has already been and will be testified to by Larry English. So the defense appears with this probation argument to try and go and skirt the court's order about the 404B evidence in a way that is speculative as to what Mr. Arbery was thinking, because this whole argument that we want to present an alternative reason for him to run away. Judge, I fully expect the defense to argue, yeah, he got spotted by Albenze. He was committing a crime. They'll figure out what that crime is and tell the jury, I guess, and that he was running away because 911 was on the way, because he has ESP and can tell that Albenze is not on the phone with somebody else, but is on the phone with 911, and that he took off running. I'm sure they're going to argue that. And the fact that Greg McMichael didn't know any of that Travis McMichael was inside that house on his sofa, that Mr. Bryan, at the time that this all took place, was fixing the front of his house, makes it completely irrelevant as to why he was running down the street. Greg McMichael's words say it all. I saw him run down the street. He was hauling ass. And that's all the McMichaels knew. So what was, again, in Mr. Arbery's mind when he did this is completely irrelevant to Greg McMichael running inside his house, getting his son, getting his gun, and getting that shotgun and getting in their truck and chasing after him. Because what Mr. Arbery was thinking at the moment he saw Mr. Albenze, they didn't even know that took place. So this appears to be, from the state's position, just a backdoor way to try and impugn his character and go from there. Yes, he was on probation in 2 cases. Those 2 cases and all that information has been excluded as not relevant. In addition, the cases that they're citing to are obstruction cases. Okay, in obstruction cases, when I see an officer who's in uniform, okay, I'm on probation, I can tell this guy may or may not arrest me. He's a law enforcement officer coming at me. So when I run from him and charged with obstruction, of course it's relevant for the state to go, well, the reason he was running, he was on probation, and he saw a law enforcement officer. So it's an obstruction case. So it doesn't really apply here, especially since the defendants had no knowledge. And once again, it's speculation as to what was going through Mr. Arbery's head. We ask that you, I'm trying to call this. My motion to ask that you grant my motion to prohibit them from going into the probation. Thank you, Judge.
That was weird.
So much for the court's instruction.
Well, if I may just respond briefly, I won't be long.
Remember,
Much
the
what
defense
Stacey
gets to
said,
speak
which
last
we
in
don't
trial.
disagree with. The fact that Mr. Arbery was an avid jogger, for example, that it was a habit and routine, for example. But what relevance is that to our case, that he had the habit of running, if not to make the inference that the state wishes to make, that that is what he was doing in Satilla Shores that day. That is what they want to do. And so the example of December 17th to support the habit theory that he's in the house and he jogs or runs away. Well, it was at night. Nobody was there. He's on a camera that he doesn't even know is there, perhaps, and no one has seen him. The difference is what I described earlier that happened on the broad daylight of 2/23/20. So I just want to focus the open the door argument. The other argument I'll leave with Mr. Sheffield, but the open the door argument is that if they want to bring in witnesses to say he was an inveterate runner and that was his habit, that's fine, but that opens the door to other reasonable explanations for why he was running on that occasion. Because it's true that one can run on a given day or even at a given hour of the day for exercise and then run on another day or another hour of the same day out of fear of being caught because he's on probation trespassing. Both of those can be true. And so it's not responsive to this argument I've made here to say that, well, he's an inveterate runner and we've got witnesses to say he ran all the time. Fine. But it's the inference they want to make that we want to be able to answer for the jury by rebutting it.
Court's going to take the matter under advisement. I'll get a ruling out prior to opening statements. The last thing I had on the state side, 4.72 is a brief on character witnesses and opening the door to character evidence. I'm just going to take that under advisement. It's a brief. I think I've gotten something similar back from the defense. There was a recently, I think, I just haven't had an opportunity to fully digest it yet, but something came back about opening the door from the defense.
If I may, I was handed by my colleagues, and I think we never titled what the brief was that we got at 8:09 this morning. I received something that I didn't receive it. I mean, I probably got it in my email, but at 8:09 I was here. So defendant's motion for the admission of evidence pertaining to Ahmuad Arbery if the state opens the door of trial to the admission of such evidence.
I didn't read the title, but that is addressed to the probation matter. That was just argued.
Well, we used that motion, I believe, to address that issue, but there are other issues that we believe become relevant, Judge, under the umbrella of open the door. And the state.
There was actually a really good article, I think, recently. It was the Georgia Bar Journal or something that talked about litigation by motion in limine. Okay.
Cobb County judge, I believe.
Was it Cobb County?
The man.
It was a fine jurist then out of Cobb County. I'm not going to do that. This whole idea of opening the door, I'm not going to prejudge the evidence that's coming in order to make a determination on opening the door and under what particular circumstances the door could possibly be opened. I'm not going to do that. Okay. I mean, I understand that the arguments may be presented that the door has been opened on something. I would suggest that if the door is currently closed, before you walk through it, we have a discussion with the court on that. Okay. I've got these competing motions back and forth that start addressing these topics. And again, I don't think motions in limine are the appropriate time to do that.
And Your Honor, if I may, that brief from the state was simply a way to keep everybody informed on what the state believes the law and the position of the law is, and to inform the court about the state's intention. The reason I did that is for what's happening here today. The defense has repeatedly told this court the state's doing this, the state's saying this, the state's going to do this, the state's going to do that. And I feel that I have not been able to adequately respond. So
She's
in
a
this case,
victim.
I did want to at least respond.
A
in
lawyer's a
writing to the
victim
court what
now.
the state's intention with these witnesses was, and to provide some law, and so that I could rely on that if it became an issue. And that was all I wanted to do. And I understand that this is a response to that. Now, my question, I guess, on this, the defendant's motion for the admission of evidence pertaining to Ahmuad Arbery if the state opens the door at trial to the admission of such evidence. Mr. Hogue, was that the brief that you were standing up here arguing and talking to the court about?
I did part of it.
Yeah. Okay, I just wanted to make sure I was on the same page. You didn't say the title, so I did not know, and I wanted to make sure I was looking at the same thing everyone else was looking at. So if that was it, then it's fine. And that is all that is. There's no need to argue. Thank you.
You know, for the sake of the record, we discussed it at the beginning of the first motion that we were taking up today about the use of force expert. We want to make clear we had adopted that motion. As to the motion regarding the THC, we wanted to adopt the motion that the Michael's pursued.
So,
on that. Third,
these are just motion and limine hearings right now?
Status in one very
So what that means is it's before the trial.
And I'm going
They're basically objecting.
We have a lunch.
So a jury doesn't hear anything, even though it's not supposed to
maybe I missed it, or
prejudice the
not
jury.
paying attention, but there seems to be some case law fairly directly on point on this subject, which no one's discussed this morning. So I want to confer with them about that. And if there's something to bring to the court, we will.
Thank you. All right. Based on my notes, then, we move into the McMichael's outstanding motions. First one I have that is still before the court. Let's see if I can get my numbering is right here. Looks like I've got, and it's actually couched as a motion associated with voir dire, but it looks like 5.7 is the motion to eliminate from the jury charge on reasonable doubt. I've got, why don't I go through and tell you what I have as open. I've got that. I have a motion regarding the vanity plate, a motion regarding Officer Duggan, hopefully I'm pronouncing that correctly, body cam, and the motion to seat all jurors in the jury box during the trial. Those appear to be the open McMichaels motions.
Your Honor, if I may, I think part of the big pot of states.
What is that thing that she has that's clicking?
For a pre-charge jury.
Every time she's up there talking, it starts
But I
clicking.
believe then we had defendants 5.6, which was the defendant's response to the court's inquiry regarding a preliminary jury instruction. That was filed on September 1st by the defense. The state filed a response September 2nd. And that's part of the pot that I think goes with 5.7.
Okay, that makes sense. I'm just trying to track it. And maybe I skipped over it because I drafted a pre-charge, which I can get to everybody this morning. I just need to print it out and get copies of it to everybody, which included the requests for basic, and I use that term intentionally, pre-charges on certain aspects of the law that I understood from reading those submissions. Everybody had agreed they wanted a pre-charge on. So I've got that. I'll go ahead and get it. I'll get everybody a copy of that before lunch. Maybe we can address all of this then after lunch, once everybody's had an opportunity to review the pre-charge.
Yes, and that is my memory of how we did it. The state moved for pre-charge. You said, well, let's all just hear what we want in that, and then you'll consolidate it and make those decisions.
Yeah.
The only part of that might be a little bit different is the 5.7 with respect to the reasonable doubt standard in the pre-charge as well as the final charge. So that might be one issue to litigate before we take a look at the.
Why don't we, it sounds like we can put the cart before the horse. I'll get you the pre-charge and you can look at the language that the court is
Oh,
using.
wow.
That language
This is
still
going to be a
appears in
long
the
one.
pre-charge, so we still do need to argue it.
This will
We
go
can
into
do that
next
once
week.
the entire pre-charge has been reviewed, and we can just take it all up at one time.
Very good.
Okay.
Thank you, Judge.
So then I have the motion in limine regarding the vanity plates.
I can imagine he has a vanity plate that says, I don't dial 911.
He thought we were doing the mathematical doubt and just stepped out.
Just stepped out.
And they are not admissible.
I was going to say, then we got the body cam, and well, why don't we go ahead and address the motion then with regard to the jury box?
Yeah, this jury box body cam. That one skip me. They just on the Kyle Rittenhouse trial, they just dismissed a guy who, a juror who told a joke on the way to his car yesterday.
Yeah, do you know if that big TV right there is connected to the internet? And if so, I could pull up the.
I love this guy with the ponytail.
Glenn County
And don't think that ponytail is not a
internet address in this motion, but
A
I looked
prop
at it
for him.
here this morning, and the numbers have gotten even better. I see.
Are you talking about the coastal health district numbers?
Let me.
I could pull up the coastal health district.
Yeah, if
numbers.
you
That's
could,
easy.
if you can pull them up for your.
I check them every day.
It's the COVID. Let me make sure it's the COVID-19 GACHD.org.
Yeah, I've got
It's
the
that
coastal health
website.
district information as well as the state DPH information, which dovetails in.
Well, I just looked this morning, and my brief's already a little bit out of date. The numbers are even better today. I got the numbers up through November 3rd, which is
There's
yesterday.
been a uniform downward trend, which we had all hoped for, given the nature of the case
Yes.
and the number of folks that we had coming in.
Well, so if you're ready for me to argue this, I will. In brief, the remedy we're seeking here is to have the jurors seated here in the jury box. 2, 4, 6, 8, 10, 12. There's 14, so we'd have to have 2 others outside the jury box, I guess. I won't repeat all the details that are in this brief concerning the importance of having a jury in the jury box. I think that's just something we all know well.
Yeah, there's no way to have a fair
over the years. As a practical matter, obviously,
a fair
so
representation
much
without the
better
jury
for
in the
all
box.
lawyers, and I hope the state may ultimately agree with me. It would be nice that we all would like to have our jury right here, and we can just do our thing here in the well of the court like we are so accustomed to doing. So the way I see it, Your Honor, is that what we're doing is trying to balance 2 competing interests here. As many decisions in life are, they're a balancing test. And on the one side of the scale, we have the defendant's rights under the U.S. Constitution and the Georgia Constitution. 5th, 6th, and 14th applied to the states for due process, the due process clause of the 14th Amendment itself, as well as the Georgia Constitution, Article 1, Section 1, paragraphs 1 and 2, regarding due process and a fair trial. On the other side of the scale, what we have in the balance is the health of the public, the health of these jurors in particular. And I acknowledge that to be a significant concern in this balancing test. And so the other part of the brief is addressing the current downward trend, fortunately, in COVID numbers here in Glenn County, suggesting that the scales could be tipping by now here in early November in favor of the constitutional rights of the defendants and the diminishing concerns for health risks to our jury. And I know that we have been here now almost 3 weeks with many people seated in the courtroom, many of us close together, not social distanced, not wearing masks even. Most of the lawyers and the defendants have not worn masks. Jurors could obviously wear masks if they're seated next to each other, and that would give them some protection. They would be closer than 6 feet, but they would have masks on if they chose to. I do note that yesterday when the jury was called into the courtroom to be told they're our jury, 5 of them did not have masks on. They were social distanced, of course, but they had chosen not to wear masks.
So tired of the word social
unless
distance.
the court ordered them to wear them because if they were to be seated shoulder to shoulder in the jury box. So if the court's checking those numbers on the website, the court will see that they're going down. And that's good. In fact, we're down below, we're at 3.9 cases now. And as of yesterday, I think when I wrote the motion, it was at 4.7 cases for a 7-day rolling average. And 3.9 now is getting way down there low. I mean, we're in the area where it's getting just safer and safer to walk around and be in closed places like a courthouse for days at a time. Anecdotally, and I put this in the brief too, as the court knows, because of the scheduling issues this court got involved in with another judge who presided over a death penalty case. I tried recently, I went to Grady County in late August the 24th, 2021, to start jury selection in a death penalty case. And we were in Grady County for 3 weeks selecting a jury up until mid-September. Unlike you, Your Honor, the judge in that case never expected or required anyone to take any COVID precautions. It was very concerning to me, and I moved to continue that case many times because of that. And finally, we got that case to trial. And for 3 weeks in Grady County, where the numbers were many times higher then in August than they are here in Glenn County right now, we had jurors at 60 at a time. I hear that too. My hearing's not even very good.
Sound like a radio outside the courtroom.
So we were in a courtroom where it was a large gallery area, and our judge called 60 jurors at a time and had them seated right next to each other in theater-like seats, and then broke them off into panels for us to do, like we've done here. We did general voir dire, and then we did individual voir dire, very similar to what we've just experienced here for 2.5 weeks. And over the course of that time, no one was social distanced. The courtroom was packed. Hardly anybody wore a mask. It was a bit bizarre, but we didn't lose any jurors to COVID. It was kind of amazing to me. We went back to Putnam County. We tried the case for 2 more weeks with these jurors seated in a jury box like this next to each other.
This guy's giving his
And only
whole
3 of them
whole
wore
thing about
masks.
why
Witnesses came
not to
in
worry
and
about the
testified. It was a
coronavirus.
2-week-long trial. And to my knowledge,
I'll probably
and
get
not
kicked off
received
of
any reports to
YouTube
the
for him
contrary,
saying this.
amazingly, nobody
But
got
that's
COVID.
his opinion. YouTube.
So I say
I,
that
of
as
course,
an
have
anecdote.
no opinions of
Obviously, that's not
anything.
evidence of what
I think
would
everybody should
happen
listen
here.
to
I mean, somebody
their
could get
doctors
COVID,
or
somebody could have it right now.
whoever else, their shamans,
But
their spiritual
because of the diminishing
medicine
numbers
men,
and the
whomever.
importance of trying this case in a normal fashion, I'd like that to note too that if we have jurors seated back here behind us, where I see those numbers on the benches, and then we have family over here, family of the defendants, family of Mr. Arbery, and I think you had media on a row, and who else? There was one other row of people, whoever. That side, I suppose, would be filled with people shoulder to shoulder, while the jurors are the only ones that would be social distanced. So I just don't know how much difference that's going to make in our fight against the transmission of COVID. There's my argument, Your Honor.
May I just add to what Mr. Hook said, not repeat what he said, which he said, well, and I kind of assume the courts thought all of this through because you've been inundated with this public health information for a long time now. So I know you're thoughtfully considering all the options in the case on this issue. The 2 concerns with the way it's set up, or 3 concerns really. In opening statement tomorrow, I'm giving opening statement from Travis McMichael. I'm going to have to address both the jury here and the jurors back there the way it's set up, which means literally talking over the state's head, which is
Won't be sitting right
won't
there.
be there. Okay, so that's obviously we're missing some information here. The other concern and bigger concern is.
Well, and just to be clear, we're shifting that table because there's a number of issues there. One is potential sightlines. 2 would be your ability to use the area as a well and address the entire panel. And 3, anything that's on the state's table doesn't need to be seen by the jury. So that table is going to be shifted to address all 3 of those issues.
Thank you, because that addresses my other concern, which is the way the jury is seated now. And Ms. Donikoski and I talked about this. Numbers 5 and 6 can see our computers. And not to mention people in the gallery, the press, the families can see our computers. And that's a real concern. And
Whether the jury was sitting there or not, there's always going to be people in the gallery behind. I'll go ahead and take a look at 5 and 6 though and try to work through that.
typically, though, in probably every case I've tried, the decedent's family is not sitting behind the defense side. They're on the prosecution side. And so we don't have that concern. I mean, it's
Oh,
another
he does have a
point
good
of
point
concern,
there.
plus the fact that they're seated shoulder to shoulder with what that does for the spread of COVID, if any concern at all. So these are additional concerns to what Mr. Hogue raised, and I would ask the court, or I would join the motion, ask the court to seat the jury in the box.
Your Honor, our concern.
How could the prosecution be
we
against
very much
that?
Appreciate the thought that's gone into the motion. Our primary concern is about the masks. Our contention is under the 5th, 6th, and 14th Amendments to the United States Constitution, the parallel provisions of the Georgia Constitution, that the defendant is entitled and his counsel are entitled to be able to see the faces of the jurors during the trial. It's important that we have that ability. Part of what
Wow.
lawyers do during a trial is they
That's
try and
true.
feedback the nonverbal communication from the jurors during the jury trial process. It's been the way it's been since the foundation of this republic.
Yep.
Given the compelling health evidence that Mr. Hogue has presented to the court, our contention is whether we seat the 14 or 16 up there in the box, or we seat them as currently planned, we believe that we're entitled to have a jury that is not masked. And to the extent it impacts that process, and I know the court is dealing with, I don't know, probably maybe unprecedented.
This is big.
Logistics issues and geography issues in the courtroom, and I appreciate that. But
I mean, it may not have a
under the
legal binding
existing
thing,
seating
but
arrangement,
historically,
the jurors
this is a
can
big
be
decision.
socially distanced, and I was hoping that the court was doing that so that they would not need to wear masks. If they're going to be wearing masks, then we certainly think there's no reason not to put them all in the jury box.
Got a point.
If they have to wear masks anyway, we might as well have them where we can all see them and not have this complication in terms of the presentation of the evidence. But our primary concern here, more so than the seating arrangements for the jurors, I'm curious about this table arrangement. So I'm not sure how that impacts us over here, but you'll tell us at a suitable time. But I am concerned that constitutionally, I think we have a constitutional right to be able to see the jurors in the jury room as the evidence is presented, to see them as we give our opening arguments and our closing statements so that we can see how they're reacting. If you're making an argument to the jury and everybody's kind of looking down or shaking their head no, or they're laughing when they're not smiling, when they're not supposed to be laughing, that's kind of a hint to counsel them. Maybe we should move on to something else. We are deprived of that nonverbal feedback when we mask the jurors. So that is our primary concern. And that is not a matter of convenience to the parties. That is a constitutional right.
That's true, man. That is a good argument.
I failed to raise, and that is that obviously any case like this, maybe especially this case, is very emotional, and the proximity of jurors to the family members on both sides is going to be difficult, maybe influential inadvertently. We would expect,
That's another
as it's
true.
been so far, that we feel the emotion in the courtroom. We would expect it's going to only be raised during the course and presentation of evidence during the course of trial. And so we think that is also going to be difficult for the jurors to put that aside, and may in fact create problems down the road, which we would all want to avoid. Thank you, Judge.
Anything from the state on the matter?
No, Your Honor, we leave it to the discretion of the court.
Her microphone sucks.
The state doesn't oppose.
They did this to her on
That's what
purpose.
they're asking. The state does not oppose sitting the jurors in the box. Obviously, these are benches. Those are much more comfortable seats. I have no idea if the court will seek input from the jurors themselves. The state's vaccinated, so I have no idea how many jurors are vaccinated. I have no idea how many would want to wear a mask, want to be socially distanced. We don't have how many want to be in the more comfortable chairs. These are all things that can be considered, but the state does not oppose the motion.
Okay. A couple things. First of all, the setup of the court is actually the setup that was part of the Glenn County jury resumption plan. This particular setup has been used, I know, by Judge Scarlett in the adjoining courtroom, which is an exact mirror of this courtroom. And that's how cases have been tried in that courtroom. I'm not sure if Judge Kelly, I assume Judge Kelly's probably tried some cases in this courtroom, but I don't know. But I know that the exact setup has been used in Glenn County for jury trials, including, I would imagine, some significant felony cases. So we're consistent with that, from what I understand. Okay, again, I'm here from a different circuit, and so I'm adopting this circuit's plan, and this is where we are. I have reviewed the plan, or reviewed the setup, and tried to work through exactly what some of the issues are, and we're still, well, I think we're most of the way there. This juror 5 and 6 issue is something I appreciate counsel brought up. I need to work through that. But the bottom line on the changes, first of all, CDC guidelines are still in place. What may have happened, and Mr. O said this, it's anecdotal, what may have been done in Putnam County, that's up to that particular jurisdiction to determine how to handle what they do, their business, and their particular approach to cases. But CDC guidelines are still in place. I think it's important, and important enough where the Supreme Court, when the Supreme Court was issuing its emergency orders, pointed out a number of times, we've got a unique set of circumstances when it comes to jurors. When we suspended jury trials, part of the calculus in that was that when we have jury trials, we are compelling members of the public to do their public service. We are not asking, we're not inviting, we are ordering people, a cross section of the community, to come into the courthouse and do what we ask them to do, which is sit as a panel and listen to the evidence. In order to do that, they need to be comfortable. In order to do that, they need to be able to sit wherever they're sitting and listen to the evidence without in the back of their mind thinking, oh, that person next to me who is shoulder to shoulder just coughed. And I just use that as an example. There are other examples I could come up with. And so the reason that this court plans to adhere to social distancing at this point is, one, CDC guidelines are still in place.
Lick their
jury plan
hands.
was enacted in this circuit and has been used. We are compelling these jurors to be here for an extended period of time. What the rest of the public does in this courtroom and what you do in this courtroom, I have not gotten involved with, because I'm not, other than the fact we're having the case and I'm telling you when to be here, it's very different from how a juror is appearing, the members of the public that are here, the media that are here. I'm not ordering them to be here. If they want to sit in this courtroom under the restrictions and the circumstances that we have, that's up to them, but that does not apply to the jury. And the court has to take that into consideration. And the jury is a significant, if not a priority for the court, to ensure that they are able to do the very important work that they are doing without distraction. So that is why we are here. As to the numbers, I agree they're coming down, but the transmission index, we can pick out whatever we want from CDC. But in my discussions with the public health department, it was suggested the transmission index is probably one of the best indicators of where we are. And because the numbers are trending downwards, that transmission index is getting lower, but it's creeping lower. It's still in the moderately high category for Glenn County. Glenn County was ravaged with COVID no more than a month, 6 weeks ago. Those numbers were extraordinarily high in this community. And so I can't imagine it's still not at least a concern to some that are coming into this courthouse. So I say all that because there are other things that I'm going to look at based on what was discussed, mentioned. I guess it wasn't really discussion. It's more of a presentation presented here. I'll consider the motion, but based on where the numbers are currently, the jury plan and the CDC guidelines, I have not seen any evidence that this court should deviate away from the circuit plan at this point. We may modify a few things, again, based on some of the comments made.
As a judge, it's his
very much
courtroom.
Appreciate the thoughtfulness of the court and all of this. The three courtrooms are close, but I would not agree to be on the record that they're identical.
It's effectively a mirror of what we've got here.
Well, I can remember, for example, at least for some years, if not still to this day, the witness chair in one of these courtrooms, the original one courtroom for Judge Williams, sits ahead of its original location because an issue came up
Love
as to
it.
the ability of the counsel and the attorneys to see the witness in the witness box. And I'll just see you. There's a history here. We also have historically had issues as to whether counsel or defendants can see the witness. Sometimes, I think it was a witness in the jury box. I can remember in the middle of a trial with an especially short client, shorter, I believe, than Mr. Bryan,
Especially short client.
sitting in here having my investigator take measurements and put them in the record. So I wouldn't be, I'm just cautioning the court, I wouldn't be so quick to rely on the fact that because other people and other judges in Glenn County have conducted court in these facilities, that you should necessarily assume that meets all constitutional or other requirements. Because that has been an issue.
I love this guy.
It's consistent with the circuit jury plan. I know Judge Scarlett's tried cases over there. In fact, he's got plexiglass up. So there's even more protection. Well, we could debate what plexiglass does, but there is more.
I kind of like this judge
outward
now. He's
signs
growing on me.
Of protection in his courtroom, and my point was simply it's a mirror. It's a similar setup. So I'll continue to work through this, probably up to the point that the jury is impaneled, and probably even through the trial itself, just to make sure that we are doing this appropriately and effectively, given the unprecedented circumstances that we are trying the case with regard to the public health issues that this community has experienced.
Discuss with the sheriff's department this morning, albeit not at the highest level, but whether there would be as an option as we're working through this, some kind of a barrier.
I've heard that as an idea, and
I think they're nitpicking right now.
just hearing it.
Everybody wants to make sure that
processing
they
it,
get to say something.
I understand it. It makes a
I
bit
mean,
of sense.
Traditionally, lawyers used to be paid
Efficiently
by
that
the
can be
word.
addressed.
Think about that one.
There's other things I need to check on.
I'm willing to help build whatever it is.
All right. It's
Did
probably
he
good
just say,
time
did
to
the
break
attorney just
for,
say, I'm willing
lunch. Let's see. It is
to help build whatever it is?
12:09. Let's plan on rejoining at 1:15. If y'all could give me a moment to print out the preliminary charge.
All right, so they're going to
anyone
come
can
back.
Maybe 5 minutes or so, grab a copy of the preliminary charge.
Had discussed in regard
I may
to
do a,
defendant's motion in limine regarding Officer
microphone.
Duggan's body cam video. I have prepared a jump drive with that video on it, and I think both parties agree that it might be more prudent it's only 7 minutes long, and the front part is about 3 minutes long, that I believe is the part's in contention. If the court wishes to look at it in camera, because of course the court's going to have, us describing it isn't going to do the court any good. So I wanted to put on the record, and that was handing you a jump drive that has
We got to fix her
Officer
microphone.
Duggan's body cam video on it from in-camera review. Is that correct, Mr. Sheffield?
Yes, Your Honor.
Just a thought before we adjourn for lunch.
Well, I'm making sure there's consent. The court
Oh.
review the video
Yes.
and camera.
Yes.
Okay. And I have been handed a jump drive, and that's the only thing on the jump drive.
The only thing on the jump drive.
Ah, I love it.
I think the court will agree that a lot of progress has been made this morning on the remaining matters before the court.
I'm going to buy everybody
We
Papa
haven't
John's.
Really begun to discuss the charge issues. I'm just throwing it out there for the possibility to consider whether we might inform the jurors that we might want them at, say, 11 or 12 o'clock tomorrow for their opening statements, because I just have a feeling that we're not going to get to everything we want to this afternoon. But I'm just throwing that out there because I know the look I'm going to get if I come up at 4 o'clock and say, now it's time to call the jurors. Just for what it's worth. I putting them back a little bit would also give counsel, and I think Ms. Dunikowski might share in that desire, to have a little more time to be ready to do the opening statements adjusted to the court's rulings this afternoon on what's allowed. Oh, I stand corrected.
No, she is ready.
I fall into this same category back when I was on the other side of this bench. What I have found, Mr. Goff, is if we give everybody 4 hours, we'll take 6. If we give everybody 6 hours, we'll take 8. I'm not going to limit. I'm going to see how much we can get through today. I'm cautiously optimistic that we'll be able to address what needs to be addressed today.
You know me, Your Honor, I'm always a pessimist.
That's why I said I'm cautious.
You know me, I'm always a pessimist.
All right, let's go ahead.
I'm a positive
and we will
pessimist.
Be in recess until 1:15.
All right, so if it's just more pretrial stuff this afternoon, I will do a short video probably on that tonight, hopefully. But that was wild. I don't know. I got a real kick out of that. I love seeing the lawyers in their raw state. You get a feeling of how they are. Of course, I mean, I'm partial to liking the lawyers anyway, because they're such a unique balance of people. But anyway, we will definitely, I'm going to come back for opening arguments. And y'all, thanks for stopping by. Please subscribe and take care. This one looks fun. Go check out the Rittenhouse trial right now. They have a guy on there who edits the videos, and they asked him his educational background, and he has a degree from Georgetown in Arabic studies. So that one should be fun too. All right, guys, love y'all. Stay safe. Don't go jogging without your personal protection. And we will see you later. Till then, peace, guys. Oh, wait, hold on. I forgot which broadcast I'm on. Ha! Bye.